Thank you very much, Chris. Good afternoon, ladies and gentlemen, and I hope everybody is doing very well in these particularly difficult times. We're all having to adapt to new ways of working, but I do say as an aside that the court appears to be coping particularly well with the current circumstances. It remains open, and remarkably, it still remains free. As I'm sure you're all aware, it's operating digitally, it's operating remotely. All documents can be filed and managed electronically, I'm told. All hearings can be managed by video link. And I understand that the court is still busily turning out judgments. We've got a new judgment from Justice Sir Robin Jacob relatively recently. And happily, I also hear that the first judgment from the court, which is one that I issued, has now been enforced, and the defendants have now paid out what was due under that judgment, which is a good example of the court's processes working from start to finish. I understand that the arbitration centre is also extremely busy with something like 70 arbitrations. And if that is correct, that is a phenomenal number for the early stages of an arbitration centre. And of course, the other thing that the registry is currently doing is organising all of these seminars. And I think Chris's programme is now up to about 18 seminars. So he's closing in, as I said previously, on a university course. So I'd encourage you to come along to as many of these seminars as possible. And of course, recordings are available of all of them if you can't make it to one of the live events. So while the court is coping particularly well, of course, we can't all be as well prepared as Chris and his team in the court registry for the current events of this world. And in countries all around the world, people have been told to stay indoors, not to go out, not to go to work in many cases. Now, in some of those countries, these restrictions are starting to be lifted, but for months, even where they have been lifted slightly, for months there have been significant restrictions on what people have been able to do, and that has an obvious capacity to interfere with contracts between parties. Manufacturing has come to a halt in many places. Travel has been restricted from people who need to do it for their jobs. Construction contracts, for example, have been interrupted all over the world. And on the other hand, there may be more indirect impacts on parties' abilities to comply with their contracts. So consumption of certain goods and services and commodities has plunged, for example, all over the world. And the travel industry in particular has taken a particular hit. And that can obviously have knock-on effects of parties' abilities to meet their other obligations. So one of the questions which will arise is what happens to a contract when there's an event which makes it impossible or very difficult for one or other of the parties to carry on? What impact does that have on a contract? Is there simply a breach of the contract? Does the contract come to an end? And fundamentally, and for me, this is the critical question in these sorts of issues, who bears the risk? Who bears the risk of this sort of event occurring? Is it the party who promised to perform but is now unable to do so? Or is it the party who was promised the performance and they may well need the performance, but they're not going to receive it? Because particularly in international commercial relationships, there's very often a chain of contracts and parties. So if you let one party out of its contractual obligations, you may end up placing the other party into breach of their ongoing obligations to someone else. So what I thought I would do in the time that I have is give you an overview of the position in English law, and then come on to take a look at the approach that's taken in AIFC law to these sorts of issues. Now, in English law, there are broadly two doctrines that I'm going to touch on. The party may either be able to rely on what we call force majeure provisions in their contracts, and that language is something which is used in many different legal systems. Or on the other hand, they may be able to show that the contract as a whole has been frustrated and so should be discharged. So starting with force majeure. Now, force majeure in English law is really a description of certain types of clause that you may find in a contract. And these clauses can take many different forms. The parties will usually define a set of events which, if they happen or one of them happens, will result in certain important consequences for the future of the contract. So the clause may say, for example, if a particular type of event occurs, say a lightning strike, and it prevents a party from performing, that party is excused performance, or alternatively, maybe they can terminate the contract. Or it may say that they can suspend their contractual obligations or be given more time to perform, or something along those lines. So what will happen is the clause will usually identify a category of events. So what kind of events are going to qualify? And the courts have made absolutely clear in England that force majeure is not a term of art which has a particular meaning in every case. Indeed, a contract which included the words "the usual force majeure clauses to apply" was found in England to be void. It was void for uncertainty. It had no distinct legal meaning of its own. So although standard form force majeure clauses can be found in lots of different types of contract, particularly construction contracts, standard form construction contracts, and those standard clauses can of course be incorporated by reference, everything, if that's not the case, then everything will depend on the language of the clause itself. And what you will normally see is a general definition of a class of events, say circumstances beyond the reasonable control of the parties. And that will be followed up by a number of examples. And they will normally be events outside the control of the party. And they will often be defined in terms of what can be foreseen, whether or not the event was unforeseeable. The second element of these sorts of clauses is that they will then explain the effect that the event must have had on the contract. And different language has been the subject of different court decisions in this field. So there is a difference between the event preventing a party from complying with its obligations on the one hand, and on the other hand, the event may hinder or interfere with their ability to perform. And as you will see, that may not in fact be required. And then the third part of these sorts of clauses is that they will then, when the qualifying event occurs, when it has the required effect on the contract, then the effect will be in the term that it will modify the party's obligations in some way. And that list of different types of modification will again depend on what is defined in the clause. So you may see clauses where performance is excused when the event occurs, or alternatively, a new obligation may be substituted, the obligation may be suspended, you may get more time to comply, or even the clause may provide that the contract simply comes to an end. Now, there are many different cases which have examined any number of different types of force majeure clauses. And so when you go to the cases, you will find a lot of explanation of what a particular clause means in a particular context. I have taken an example from a recent case in England. Nothing particularly remarkable about this clause. I use it because it is the most recent example of a High Court judgment from England on a clause of this sort. It's a decision from the 20th of April of this year. And we can see that each of the three features that I've been describing arise in this clause. So you have a definition of the trigger event, circumstances beyond the reasonable control of the parties, and then a list of qualifying events. So we have fires, floods, wars, riots, and, by the way, pandemic. So some prescience there in the clause. We see the effect that the clause must have on the contract, or the event must have on the contract. It must cause a failure or a delay in performing. And then we see the consequence once those requirements are satisfied. There is a modification of some of the obligations under the contract. There's a suspension of the obligation, and then there's a new obligation to remedy and resume operations. So the clause sets out rules for how the contract will operate when an unforeseen interruption occurs. And it operates, as we've seen, as a term of the contract. Now, part of the effect of these sorts of clauses is very often to save one of the parties from being liable for breach of contract. However, strictly, the approach in English law is that a force majeure clause is probably not an exemption clause. It probably doesn't qualify in the legal definition of exemption clauses. Now, that may come as some surprise, particularly where, as in the clause we've just been looking at, the first part of the clause starts, neither party shall be liable. But in a case from 1957 called Fairclough, Lord Tucker said this. He said, force majeure clauses are of different kinds. In the case of an exception clause or exemption clause, it's generally true to say that it only operates on the happening of an event which would otherwise result in a breach. But there is nothing to prevent the parties providing for an extension of time for performance or for a substituted mode of performance on the occurrence of a force majeure event, whether or not such event would have prevented performance. So while exempting parties from liability may well be part of the mechanics of most force majeure clauses, the essence of those clauses is to adjust the party's obligation when a qualifying event occurs. Now, in fact, this distinction between force majeure clauses and exemption clauses may not matter so much. Defining an exclusion clause, a clause as an exclusion clause in English law, can have some importance because exclusion clauses are subject to various kinds of control in English law. Firstly, they are narrowly construed, they are narrowly interpreted. But according to English courts, force majeure clauses are also construed very narrowly as well. They're often understood to be concerned with things that could not be predicted in particular. And if we go back to the clause we were looking at, we can see an example of this. So this is the clause that we were looking at earlier. And this arose in a case which was to do with some rioting which occurred, unfortunately, in London. There was some widespread rioting in August 2011. And in the course of that rioting, a warehouse was looted and was then set on fire. And the fire actually ran for about 10 days in that particular warehouse. And needless to say, there wasn't a lot left of the contents after the fire was put out. And so the party who was storing their goods in that warehouse brought a claim against the owners of the warehouse for interruption to their business and for various other losses. And essentially, what they were complaining about was they said, well, the owners hadn't properly secured the premises against trespassers and rioters, and they had not installed proper fire protection for the premises. So the question for the court was, were these circumstances events which fell within the meaning of this particular clause? Now, the clause refers to fire and it refers to riots, but the clause clearly wasn't saying that all fires, for example, fell within the clause. So the list of factors, fire, flood, riot, they were all qualified by the requirement that they had to be beyond the reasonable control of the owner. And for the court, that involved considering what could have been reasonably foreseen by a party in the owner's position. And because that determined what that party could have done about those sorts of risks. Now, the owner's position was that this was all caused by rioting, and riots were unprecedented. Nobody foresaw or could have been expected to foresee the riots. But the court said they could have been expected to foresee the possibility of trespassers coming onto the property. And indeed, there had apparently been attempts to trespass on the property in the past. And in addition to that, fire generally, and arson in particular, could have been foreseen on the basis of industry guidance in relation to that. So then the question for the court was, given that those things were foreseeable generally, should the owner have done more to prevent the risks? And if they had done more, would that have prevented or reduced the damage to the stock, which was the subject of the claim? And the answer for the judge was yes, because the security on site was found to be inadequate, as was the fire defence in that there was no sprinkler system. So what you can see here is an application of the relatively narrow construction given to these sorts of clauses in English law. On the one hand, the court might have said, look, this is damage caused by a riot. Riots are beyond the control of the parties, and therefore it's within the scope of the clause. but instead the court adopted a more nuanced and critical approach to the questions that were posed. Now, the other reason why exemption clauses are significant as a category of term in English law is because they're subject to statutory control in England in the form of the Unfair Contract Terms Act. And there are similar controls in the AIFC regulations in the implied terms in contracts. And in particular, if we look at section 4 of the regulation, says that exclusion clauses in qualifying contracts may be ineffective, for example, if they seek to exclude certain types of liability for negligence or they are unreasonable. Now, under English law, force majeure clauses are also generally subject to the terms of the Unfair Contract Terms Act. Now, the English law position has changed a little bit, but the equivalent AIFC provision is in Article 41. And we can see from that attempts to exclude or restrict liability are covered, as are clauses which change the contractual obligations substantially. And so Article 44 of the AIFC regulation also sets out a relatively broad approach to what counts as an exclusion clause. So the difference between exclusion clauses and force majeure clauses in English law, and also it appears potentially in AIFC law, may not be quite as important. And of course, as I say, force majeure clauses often do more than simply exclude liability. Now, I'll come on to AIFC law in a minute, but given the English approach to AIFC, to force majeure is entirely based on contractual interpretation. It sees these clauses as simply elements of a contract. There's no obvious reason why the English approach should not be relevant to these sorts of issues under AIFC law. And a question that is often asked is, well, can the AIFC judges, can the AIFC court look at English case law or judgments from other common law jurisdictions to decide cases that come before it? And the answer to that question, or at least part of the answer, we can see is in the AIFC constitutional statute. And Article 13.6 of that says that in adjudicating disputes, the AIFC court is bound by the acting law of the AIFC and may also take into account final judgments of the AIFC court in related matters and final judgments of the courts of other common law jurisdictions. So the judges of the AIFC court can look at common law case law to decide these sorts of issues in principle. And I can say that if I was looking at an international commercial contract and I was trying to decide what a force majeure clause meant, I would very likely be interested in knowing about the approach of other common law jurisdictions to those sorts of clauses. However, of course, I need to sound a note of caution, because I think one always has to be very careful about applying decisions or judgments which interpret contractual clauses. In practice, we often used to say that you can make these sorts of judgments say whatever you want them to say. And that is because they are always tailored to the specific factual context in which that contract was agreed. And so the same words in a different contractual context can very often do have a very different meaning. But subject to that, I think in general terms, the common law approach, the Commonwealth approach to these sorts of clauses would probably be of interest to a judge in deciding what they mean. So that is a brief tour of the English approach to force majeure. The other potential effect of a disrupting event in English law is that the whole contract may simply come to an end. And that is the result of the doctrine of frustration. Now, this is a doctrine which has ebbed and flowed a bit in English law, and I would say in recent years has somewhat dwindled. At its heart, though, the effect of this doctrine is that the contract may be discharged entirely if something happens after the contract is concluded, which either makes performance impossible or which changes the obligations of the parties into something fundamentally different. It generally has to be an act which is outside of the control of the party relying on it, and it has to be an act for which, an event for which they cannot be blamed. And the effect where this happens is the automatic discharge of the contract. Now, in the modern world, as I say, this doctrine has dwindled somewhat, and it is right to say that it is applied very narrowly. And the general approach these days is that parties should not be let out of their contracts simply because they made bad bargains, or, and this may ultimately be another way of saying the same thing, because they failed to predict the many ways in which things might go wrong in relation to the contract after it was entered into. Now, some of the older cases on frustration appear to be really quite surprisingly permissive. And this is all thought generally to have started in about 1863 with a case called Taylor and Caldwell. And that was a case in which a party had hired a music hall to put on 4 concerts, but before the concerts could take place, the hall burnt down. And the English courts decided that the owner of the hall would be excused performance and therefore excused liability for non-performance of that contract because performance would be impossible. Now, the way they dealt with it at that point was to treat it as, in effect, an implied term in the contract. But this ultimately became the doctrine of frustration in English law. And you might be slightly surprised by the outcome of that case, because if it comes down, as I think it should, to who bears the risk of these events, who bears the risk of the hall burning down, well, one might say, well, fire is something that owners of buildings generally insure against. They generally insure themselves against the risk of their own buildings burning down. But certainly it's right to say that destruction of the subject matter of a contract is one recognized category of event that can lead to frustration of the contract. One of the other really important categories is supervening illegality. And this occurs when the performance of a contract becomes illegal after it is entered into. And it's often because of a change in the law. And quite often that has happened during wartime, when the government has invoked wide-ranging wartime powers, for example, forbidding parties from entering into contracts with enemy nations or with their subjects, or sometimes simply prohibiting particular contracts or requisitioning the means of engaging with those contracts or completing those contracts. Now, war is the most obvious period of national emergency, which leads to this kind of legislative change. But we are, it seems to me, living through another one now, as a result of which many activities which were previously lawful were forbidden or have been forbidden, some still are, by law in countries across the world. And in particular, leaving houses, going out and participating in social events. Now, no doubt we will see disputes about these sorts of things emerging, about whether or not, as a result of that sudden change in legislation, contracts have been frustrated as a result. And where the law which changes is foreign law, the position is rather more complicated. It may frustrate a contract if the law changes to make performance illegal at the place where it is to be performed. But this is historically a very important category of frustrating event, and one which we may well see more of as a result of the current circumstances. Now, historically, the cases have indicated that frustration of the wider purpose of the contract may also be enough in certain circumstances. And the most famous of these cases, and the one which has been most criticized, is probably the Krell and Henry case. That was a case in which a party had rented some rooms in London because they wanted to go and watch the coronation of King Edward VII. And unfortunately, the coronation was cancelled on 2 days' notice. And I understand the details are rather gruesome, but it's suffice to say that the king had to undergo an operation, apparently on the table or in the music room at Buckingham Palace. This was all rather unexpected. And so the court in that case found that the whole purpose of the rental agreement was frustrated, and they said it had been discharged. Now, as I said, there's been plenty of criticism of that particular case, and it's fair to say it's regarded as an exception rather than the rule. And there are decisions on somewhat similar facts which have gone the other way. And I've put there the case of the Herne-based steamboat company, which was decided around the same time, where a party had hired a steamboat for viewing a naval review and to cruise around the fleet. And even though the review was cancelled, they were still bound to the contract. So the court there took a very different approach from the Krell Henry case. Now, this is an objective case, objective test. The question of whether or not a contract has been frustrated is not about what the parties themselves anticipated. And the court will consider a range of factors, including the parties' expectations as to risk, so far as those can be determined objectively. And most of that will come from the contract and from the factual background in which the contract was agreed. And that's one of the reasons why frustration is very rare these days, particularly in commercial contracts, because the contract will generally contain a force majeure clause, which is an attempt to allocate the risks of unforeseen events and to dictate what's going to happen next. And if a contract says what happens when an unforeseen event occurs, and that changes the contract and modifies the obligations in some ways, then what would need to be impossible would be performance of the contract as modified. Otherwise, one could still carry on with the contract in its modified form. So unless you get to that level, then there is going to be no room for the doctrine of frustration. And so very often, the answer to any arguments on frustration will be found in the force majeure clauses. Now, as I've said, the effect of frustration is rather dramatic. It simply discharges the contract automatically. It doesn't require an act by the parties. It doesn't require an order from the court. It's not brought to an end ab initio, that is from the beginning. It simply stops everybody having any further obligations going forward. And in the past, that had some really quite unjust effects under common law, because everybody would just be left with whatever they had paid not being recoverable and not getting any performance going forward. Now, there is now a statute which sets out how parties must account for the value of money that's been paid, for any expenses which have been incurred, and for the value of goods and services that have already been provided under the contract. And so the position has been made somewhat easier by statute in England. Now, there's much more that can be said, much more that has been said and has been written about the doctrine of frustration in English law, but hopefully that gives you some sense of the shape of it as a matter of English law. Well, the next question then is, well, what about AIFC law? How do these sorts of events feature in AIFC law? And the first thing you will notice about the doctrine of frustration when you look at the AIFC contract regulations is that it doesn't appear to exist. Indeed, if you look at Article 36, that makes clear that impossibility that existed at the start of the contract does not affect its validity. Now, under English law, impossibility which already existed at the start is usually understood to be the territory of the legal doctrine of mistake, and that's dealt with in the next article of the contract laws. But as I say, there is no express concept of frustration set out in the AIFC contract law. So then what happens in the event, if some event occurs, some supervening event, which makes performance impossible? And that is the area where frustration operates in English law. Now, these sorts of events are dealt with in Article 82 of the contract regulations. And there it says, except with respect to a mere obligation to pay, non-performance by a party is excused if that party proves that the non-performance was due to an impediment beyond the party's control and that the party could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. So broadly, non-performance is excused if it's due to an impediment beyond the party's control and that they could not reasonably have been expected to take it into account or to overcome its consequences. Now, if the effect of the impediment is merely temporary, then it simply postpones the obligation. So once the impediment is lifted, you then have to perform. But a permanent impediment presumably therefore results in a permanent suspension or a termination in effect of the obligation. So this looks rather like a force majeure clause in English law. It is almost as though a force majeure clause has been implied into every contract that is governed by these regulations. Could this override an existing force majeure provision in a contract? Clearly that will be open to argument. My preliminary view, though, would be that it wouldn't, for the same reasons that frustration tends not to apply when you have these sorts of clauses. Because if the parties have agreed to modify the bargain in the event of disrupting events, then it would have to be the performance of those modified obligations that would need to be impossible to trigger the effect of these provisions. But what about permanent impediments? We can see that non-performance is excused, but then what? What happens to the contract? We get some insight into that at subparagraph 4. Nothing in this section prevents a party from exercising a right to terminate the contract or to withhold performance or request interest or money due. So it looks like a party who is not getting their performance, the performance that they were promised, they can still terminate on the basis that there is fundamental non-performance of the contract. So the provision generally operates to save parties from liability for damages for breach of contract, but it doesn't save them from the other consequences of non-performance, such as giving the other party a right to terminate the contract. But there is no concept, at least in these provisions, of automatic frustration. And perhaps that makes sense in a regime where, in effect, the law has introduced a force majeure provision into just about every contract through the operation of Article 82. So while we see echoes of certain concepts present in English law, this is not really much like the English approach. And one has to ask, well, why is that? Why is the AIFC law so different from English law? And it seems to me that the answer to that is in the source of AIFC contract regulations. They are not based on English law at all. They appear, in fact, to be based, well, first they're based on the DIFC law of contract, and that in turn is based on the Unidroit principles for international commercial contracts, and in particular the 2004 version. And that makes sense because the DIFC contract law was issued in 2005. And you can see the very similar provisions to what I've just shown you appear in Article 7.1.7 of the Unidroit principles, and that has survived in very similar form in later provisions, in later iterations of the rules. There is one very significant difference, which is that if the obligation you are concerned with is for payment of money, then there are no excuses at all. We saw that in Article 82, where it carves out obligations in respect of payment of money, but Article 83 makes that clearer still. It says, if a party who is obliged to pay money does not do so, the other party may require payment, notwithstanding Section 82. Now, that could be significant. I've personally seen quite a few cases in my practice in which parties have been claiming that they're unable to pay money. And it's usually because they've been made subject to, say, a court order or an injunction requiring them not to pay certain money. Or it may be other excuses I've seen relate to currency controls, for example, in the country where the party is operating. And so that may well be, and often is, given as an excuse for example, not paying out under a guarantee or something of that nature. And under these sorts of provisions, it appears that those sorts of defences won't help. So that is potentially significant. The other point to raise about the origin of these regulations is that they bear a striking similarity to the United Nations Convention on Contracts for the International Sale of Goods, and in particular Article 79, two of those. But it's important to see that Article 79 is somewhat different. There are some differences, but they are substantially the same. And that is, in my view, a good thing. Why is that? It's because the United Nations Convention in particular has a very long history and quite a track record in front of very many courts. And the United Nations regularly produces digests of international case law which apply the terms of the conventions and of the conventions which are issued by them. And this particular convention is no exception. And so the most recent of those digests was published in 2016, and it pulls together a wide range of decisions from a lot of different countries. And so it's a helpful resource in understanding how courts around the world have understood that particular convention. Now, I should say there are very few decisions in there coming from common law jurisdictions. The one exception is the United States of America, where there are quite a few decisions. There are one or two decisions from Australia, a few from New Zealand, but barely a mention from England. So I suppose that applying the letter of the constitutional statute, does that mean that we can't refer to those sorts of decisions because they come from civil law courts? Well, we'll see if anyone raises that point, and we'll have to decide it then. I would have thought at first blush that the AIFC Court would also be quite interested to see how judges from other civil law jurisdictions also approach these things, even if they're not bound by any of those sorts of decisions. The other thing to note is that the AIFC law, like the convention, does not include remedies for hardship. Now, the unidroit principles do include those sorts of provisions. And so the unidroit principles say, for example, where an unexpected event occurs, which increases the cost of performance or reduces the value of performance so much that it fundamentally alters the equilibrium of the contract, then that may lead to renegotiation of the contract, termination, or even court adjustment of the terms of the contract. Now, some commentators have suggested that in the context of the United Nations Convention, there's room for including hardship, this wider concept of hardship, within what is understood to be impediment, the kinds of impediments that are concerned, that the convention is concerned with. Now, we'll have to see whether or not those sorts of arguments are advanced in relation to the unidroit rules and therefore in relation to the AIFC regulations. But again, just looking at it at first blush, I suspect that many common lawyers would find the concept of hardship somewhat alien. So there are some differences, but I also think there are such close similarities that it may well be that lawyers, practitioners, and the court can find some resources which they can deploy, which give them some guidance as to how these sorts of provisions are intended to operate. And with that, I complete my presentation. Thank you very much for taking the time to review this. And I must say, I think this is a particular area where it will be extremely interesting to see how the law develops over time. Thank you very much.